Hello again. This is the American Presidency course and the continuation of our sequence of discussions of the presidency and the Constitution. This is the final part in this discussion series. During this part, we will talk about whether or not the president uh, is limited in his power to the extent that the founders would want him to have been limited. We'll talk a bit about whether the founders might approve of the modern presidency. So without further ado, let's go ahead and share the screen and get into the lecture slides for this final presentation. Okay, as I said, this is the part 5 of the presidency and the Constitution. What would the founders say about the modern presidency? We begin with that question. It's a bit of a loaded question that really doesn't take into account who the founders were. We tend to use the word the founders and think of them as a monolithic group. But it's quite likely that we need to think of the word founders as a more diverse group. They had diverse interests, diverse opinions. Not everyone was in agreement with the form of government that resulted. As I said in an earlier lecture, the seeds of partisanship existed during the Constitutional Convention and certainly emerged in full force during the ratification conventions. So either way, whether you think of the founders as this monolithic group, as we were prone to do today, or as a group who had diverse interests and opinions, it's important to think about the motivations of the presidents, of the founders, and self-interest was the motivation of all of them for establishing the new government. As we talked about earlier, there was an abiding fear among many of the founders of the events that occurred and were occurring in the much too democratic states for their tastes. Many of the state legislatures had been taken over by small farmer and laboring interests. In those states, the legislatures that were in control of the currency simply inflated them, making it easier for debtors to repay their debts. This practice was basically seizing the private property, that is the debt instruments of the creditors, because the debt, as inflation occurred, the debt instruments became easier to pay off and of less value in terms of gold and silver. Many of the founders were among this class who held debt instruments as a result of the American Revolution, and their property was being devalued in these state legislatures that had been taken over by the small farmer and laboring interests. In other states where the creditors, that is the property class, maintained control of state legislatures, rebellion had occurred. In particular, Shays' Rebellion in Massachusetts sparked fear among many of the founders who desperately wanted to protect their private property, that is their debt instruments, valued investments. So the implication of the mindset that existed and was prevalent at this time affected the design of the new government, and the implication for presidential power was fairly clear. The founders wanted to limit the new government in its ability to take decisive policy action. That was essential to protecting their property from inflation and taxation. And you can see my chapter 2 for a more lengthy discussion of these issues and ideas, including discussion there of the many elements of Article 1, Section 8, the legislative power that dealt with the powers of Congress and how it tied in with protecting private property. One aspect of limiting power for the national government was a system of separated powers. The legislative, judicial, and executive organs would check one another in the event that one of them got out of bounds. Of course, that holds large implications for executive power. Presidents were given power relative to the legislature because of this separated powers system. The presidential veto power is by far the most important of these. It was not used very much initially until Andrew Jackson, and Andrew Jackson was the first president to make extensive use of the veto power. Presidents could also issue a statement on the State of the Union, as well as propose necessary and expedient measures to their consideration. This was hardly used at all until the Theodore Roosevelt administration. The legislature was also dependent on the executive for policy administration. Presidents were given power relative to the courts as well. The judiciary is actually totally dependent on the executive for carrying out its decisions, especially those that require enforcement, such as the busing decisions in the 1960s and 70s. In fact, there's a nice book entitled "Must We Bus" by a scholar named Greg Orfield, in which he argues that the Nixon administration engaged in a deliberate strategy of not enforcing the busing decisions. Again, that's an example of how the judiciary is dependent on the executive, and policy may go awry as a result of the executive not acting. The Congress and the president, as co-legislators, can legislate the court's appellate jurisdiction. They can, as co-legislators, adjust the size of the court. The size of the Supreme Court has varied from as few as 5 all the way up to 10 members. And in the latter part of the 19th century, the size of the Supreme Court settled in at 9 and has remained that since. Also, Congress and the president can legislate the court's the appellate jurisdiction and size with respect to the lower courts. For example, Thomas Jefferson in the early 19th century directed the Supreme Court justices to not sit on a bench and deliberate, but to ride circuit. Of course, this was quite onerous to many of the sitting Supreme Court justices because they were quite elderly, and riding circuit was a tough job, one that was important for younger men. And so this was an effort on the part of Jefferson to get some of the justices who had been appointed by Washington and Adams to resign from the Supreme Court by forcing them to ride circuit. Or another example, George W. Bush proposed legislation that would limit the court's jurisdiction on the Guantanamo detainees. And these laws were passed, the Detainee Treatment Act of 2004 and the Military Commission Act of 2006. So presidents had power then as a result of the founders' intentions to limit the power of the courts. On the other hand, presidential power is also limited by Congress and the courts. Much presidential power depends on Senate affirmation, confirmation. Treaties require, as you know, a 2/3 vote of the Senate. Appointments require a majority vote of the Senate. And if the president can't get that, then it leads to a government of heads of departments who are merely acting appointees rather than full appointees. Congress funds any activities of the executive that requires money. And so Congress affects the presidency by either increasing or decreasing the amount of money that is available for the programs that the president executes. Congress is empowered to legislate the authority and design of the executive itself and its various departments and agencies. And that includes the White House itself, the White House staff. Congress has created offices in the White House and also limited the authority of other offices in the White House. So Congress has significant control over the form of the White House. While it is not explicit in the Constitution, Congress has the power to investigate the executive, and this is implied by the list of legislative powers in Article 1, Section 8, and especially by the necessary and proper clause. So Congress is given power to conduct oversight of the executive, both oversight of the White House as well as oversight of the executive branch agencies that operate. Congress also has the authority to impeach and remove a president. Again, a limitation on presidential power. The courts, even the lowest district courts, have the authority to evaluate the legality of presidential acts. And of course, this is implied by Marbury versus Madison in 1803. This last feature, limiting the president, has become really important during the Trump administration, with time and again the lowest district courts striking down the president's orders and proclamations. It's easy to see from that discussion that the presidency was designed to limit the power of the Congress and the courts, but it was also designed to have limited power itself. Yet, the consensus of the convention also favored an energetic executive. Components of an energetic executive are laid out and rationalized in Hamilton's Federalist 70. I encourage you to read Federalist 70. The three features of an energetic executive laid out by Hamilton were unity, duration, and adequate provision for support and competent powers. Why unity? A single executive is more decisive and accountable. Plural executives or executives advised by a council are by definition less decisive due to differences of opinion. They are also less accountable in that they can defer blame. Duration. Why duration? It takes time to learn the office and to execute it well. Debate over the period of service of the president ranged from one 6-year term that was non-renewable to tenure for life upon good behavior. That was Hamilton's proposal. The convention settled on one 4-year term that could be renewed in perpetuity. This decision remained in effect until the 22nd Amendment to the Constitution, ratified in 1951. Franklin Roosevelt was the first president to serve more than 2 terms, though Woodrow Wilson actually wanted to serve more than 2 terms, but did not achieve the nomination of his party for the 3rd term. Eisenhower was the first president to serve under the terms of the 22nd Amendment. So Eisenhower was the first president who constitutionally could serve no more than 2 terms. Adequate provision for its support and competent powers. Executives need support and authority to be able to competently execute the law. An energetic and adaptive executive is also enabled by Article 2, Section 1, Clause 1 of the Constitution, which is the vestment clause. It states, again, repeating, the executive power shall be vested in the President of the United States of America. This single clause opened the door for the expansion of the executive power through time. As we will see in the next module, the expansion began very early in the Washington administration and continues to the present. Yet, the executive power is limited subsequently by the Take Care Clause of Article 2. It states that the president must take care that the laws be faithfully executed. This clause in the Constitution imposes a duty on the president to enforce the laws of the United States, and I've got there in bold, even if he disagrees with the purpose of the law. This extends also to federal court rulings, and thus George Washington interpreted this clause as imposing on him a unique duty to ensure the execution of federal law. Discussing the Whiskey Tax Rebellion, Washington observed, "It is my duty to see the laws executed. To permit them to be trampled upon with impunity would be repugnant to that duty." So presidents are required by the Take Care Clause to execute the law, whether they agree with it or not. Of course, Eisenhower, Dwight Eisenhower, it is well known that he did not agree with the Supreme Court's order to desegregate the public schools following Brown versus Board of Education. Nevertheless, he was directed by the Supreme Court to assist in desegregating the schools in Little Rock. And of course, he was obligated to comply, and the schools were indeed desegregated in Little Rock, Arkansas. As we talked about earlier, the founders were not a monolithic group who uniformly supported every aspect of the new governmental system. There was heated controversy over the design of the presidency. Read James Madison's letter to Thomas Jefferson. Jefferson had not attended the Constitutional Convention, and Madison wanted to apprise Jefferson of what had occurred in the Constitutional Convention and what the new proposed Constitution looked like. Jefferson, who was serving as ambassador to France at the time of the convention, was rather ignorant of what occurred in the convention. So Madison described the torturous deliberations, offering a very detailed account of the factions supporting and opposing the design of the presidency and why. He stated, "The first of these objects, as it respects the executive, was peculiarly embarrassing." Why embarrassing? On the question whether it should consist of a single person or a plurality of coordinate members, on the mode of appointment, on the duration of office, on the degree of power, on the re-eligibility, tedious and reiterated discussions took place. The plurality of coordinate members had finally but few advocates. In other words, the final product of the presidency was not one that was supported by consensus. There was dissensus regarding the final form that the presidency would take. In other words, the founders basically gave up in their deliberations, and the presidency was not a result of consensus, but rather resulted from the last proposal on the table, as the founders were anxious to conclude the deliberations. Some thought that the resulting design of the presidency was perilous. In Cato 4, George Clinton argues the perils of a single executive. He says a single executive without an advisory council invites ill-informed decisions. A lack of a term limit invites lifetime tenure. These and other features invite monarchy and elite governance. The chief complaint then by Clinton was that presidents would become like kings and their cabinet like their courts. Thomas Jefferson wrote back to James Madison, and in his letter, he states what he does and does not like about the proposed new government. Concerning the presidency, he stated, "The second feature I dislike and greatly dislike is the abandonment in every instance of the necessity of rotation in office, and most particularly in the case of the president. Experience concurs with reason in concluding that the first magistrate will always be reelected if the Constitution permits it. He is then an officer for life. This, once observed, it becomes of so much consequence to certain nations to have a friend or foe at the head of our affairs that they will interfere with money and with arms. So Jefferson is fearful that the design of the presidency, especially that aspect of the presidency by which he is free to be reelected in perpetuity, is an invitation to monarchy. And of course, they just fought a war to get out of a monarchy. Others thought the design of the presidency was well thought out in limiting presidential power. For example, in contrast with Clinton and Jefferson, Alexander Hamilton, writing as Publius in Federalist 70, laid out all of the ways a president would not be like a king. He notes that kings are not elected like a president, but are hereditary. He noted that kings serve for life and pass down their office to their offspring. Presidents are elected and may be removed or not reelected. Kings have an absolute veto over legislation, while presidents do not. Kings declare war, raise and fund the military alone. Under the new government, Congress declares war and raises and funds the military. Kings alone make treaties. Presidents make treaties with Senate approval. Presidents nominate, kings appoint, and so forth. So Hamilton is arguing that the president is nothing like a king and will be nothing like a king. Were the presidents successful in creating a limited presidency? Presidents today often take unilateral executive actions based on the unitary executive theory that can only be overturned by Congress, subject to a presidential veto or the courts. These include executive orders, directives, proclamations, and policy statements. In foreign policy, presidents negotiate and sign executive agreements that have the same force as a treaty or a law. Presidents are the sole organ for United States foreign policy. A hot link there, go read about that. We'll talk about it in the next module. They negotiate executive agreements with and without the consent of Congress. This is the difference between a sole executive agreement and a congressional executive agreement. Again, we'll talk about that in the next module. Presidents have also made war consistently through American history without a declaration of war by Congress. In many, if not most of these instances, presidents have asked for congressional authorization to use military force. In more recent times, presidents have encouraged congressional authorizations, but have not deemed them as necessary. The earliest instance of presidents making war without a declared war, the first instance was the quasi-war with France, which started in about 1798. This was a naval war with France to settle issues concerning the impressment of American sailors by the French. The Constitution distinguishes between declaring war, Article 1, Section 8, and engaging in war, Article 1, Section 10, Clause 3, or levying war, Article 3, Section 3, Clause 1. Implied by that distinction in the Constitution is that presidents can make war, but only Congress can declare war. In domestic policy, presidents since Reagan have often issued signing statements when approving legislation. This practice reached a nadir during the George W. Bush administration. As of January 30th, 2008, Bush had signed 157 signing statements challenging over 1,100 provisions of federal law. It is important to note regarding signing statements that A, no U.S. constitutional provision, federal statute, or common law principle explicitly permits or prohibits signing statements. However, there is also no part of the Constitution that grants legal value to signing statements. Article 1, Section 7 in the Presentment Clause empowers the president to veto a law in its entirety, to sign it, or do nothing. Article 2, Section 3 requires that the executive take cares that the laws be faithfully executed. The Constitution does not authorize the president to cherry pick which parts of validly enacted congressional laws he is going to obey and execute and which he is not. So presidents, though, since Reagan, have done just that. Evidence that the founders intended an adaptive presidency. On the other hand, Article 2, Section 1, Clause 1 is very general in stating the executive power shall be vested in a president of the United States of America. Is that broad statement and failure to define what executive power is subsequently an evidence that the founders understood that presidents should or would become more powerful through time, through adaptation, through assuming what would normally be thought of as executive power? Or was that broad statement and failure to define executive power a result of an inability to decide by the framers, as is suggested in Madison's letter to Thomas Jefferson? Also, given that Congress was very specific, was given very specific checks on the presidency in Article 1 that limit executive power, treaties, appointments, veto overrides, can it then be inferred that all remaining executive power belongs to the president? Okay, concerning that question, see the debate between Hamilton and Madison, labeled Pacificus and Helvidius at the link that I have marked here. As you can see, we have reached the end of the slides associated with Part 5 of the President and the Constitution. And thus, we will be moving on in subsequent periods to discussion of the evolution of the presidency. That discussion will talk about how the presidency has evolved from 1789 all the way up to the present. During this session, we have talked about the generalities of presidential power and how presidential powers are tied to the Constitution and the concerns of the founders, what motivated the founders, in other words. And we've talked a little bit about some theoretical questions concerning, what the executive power is. Is executive power basically what the president decides it is, or is executive power limited in some way? Okay, so I will stop there and we will resume in the next module. Good day.